I want to take today to spin the block on the Holly Johnson, also known as Quadajah, Holly Johnson pre-trial release, okay? I know I spoke about it while I was out at my family reunion, but I wanted to spin the block because, baby, we got some people that got it very confused. And I want to break it down, not so much for them, but for you guys, okay? If they want to be confused because you still have somebody on there hollering, she ain't coming home. Holly not coming home. People lying to y'all. She ain't coming home. But nevertheless, child, listen. We're not only going to talk about the fact that she is coming home pre-trial, but we're going to talk about the pathway for a not guilty verdict, okay? And we're going to talk about, did the appellate court expose weaknesses in the state's case, all right? So I wanted to know a clearer pathway for Quadajah, Holly is what we call her, and what it looks like now that the Supreme Court elected not to get involved, and they are standing with the appellate court and saying, hey, if the appellate court says send her home, okay? Now, listen, I don't know what all channels y'all watch or listen to or whatever the case may be, but there are people out there that's putting out false narratives that the reason why the Supreme Court did not want to get involved is because she is pregnant. Baby, y'all, if y'all could believe that if you want to, but I'm telling you, that ain't it, okay? That is absolutely not it. So I'm going to go from the top, and I'm going to go back over what the appellate court said that that the reason why she should be released pre-trial. Now, let me say this. We said pre-trial, right? She's been locked up since December. And the state of Illinois has said that she is a danger to the community. We have been saying over here on Talk About It with Amoira and a few other channels that she is not a danger to community. And we've said, how can she be a danger to community when Romika is the one that pulled up on her, okay? This young lady has been a weapon license carrier for a while. She didn't just get it yesterday. Like 5 years is what I heard. Now 6, right? 6 years in the making. And all of a sudden, out of 6 years, she just became dangerous overnight. That's not how that happened, right? She literally would not have had to utilize her weapon if somebody like Romika would not have pulled up on her, right? So she's been locked up since December. And it would be 7 months by the time that she gets out because she's still not getting out until July, right? Which sucks, but nevertheless, let's get into the state tried to pull a fast one. Now, in my opinion, I believe the state and the judge let me see, how do I say it? The judge normally leans on the state's side unless there's more evidence that show that, is not what they said. So I will say that about the judge. The judge was leaning more on the prosecutor's side, and the prosecutor deemed Holly Johnson as being dangerous to the community. And they went even forward as saying she shouldn't be released because it was daylight outside, kids were out there, people were walking past, and basically that Romika was unarmed, okay? So they were making it seem like she took an argument and allowed it to escalate into a murder, okay? Now, we all know that that's not true. That's not the full picture. From what we found out from pulling back the onion, and let me just say this before I get too far. I'm grateful that this case wasn't gagged, okay? Hushed. And the reason being is because we would have only had one side of the story, and a lot of people would have still been going along with the narrative of Romika was this nice, calm, loving mother that, was minding her business and just pulled up to talk to her baby daddy, and jealous old Holly got involved and started talking to her, and that she was the aggressor and all that stuff. That would have been able to fly had this case been gagged. So I'm glad that the judge pushed back on Ari and did not gag this case, okay? Didn't silence it or anything like they did the Carmelo Anthony case. Therefore, we were able to dig a little deeper, and we found out that Romika was a whole menace to society out here while she was live, scaring people and threatening people and bullying people and laying hands upon people, okay? So, nevertheless, we found out that it was so many lies pushed out here that Holly was just this jealous person. She really, really wanted Carlos, and that, they wasn't even together, and she wasn't even over there for the weekend. She was stalking Carlos out. Y'all heard all the rumors or whatnot. However, I like the way Ari has spelled everything out in all of these motions that she done put forth, even at the circuit level and the appellate level. And she laid out the story that we have been telling on this here platform, okay? So I like the way the appellate court reiterated her arguments. And they used some of her arguments as the reason why they said the state did not prove that Holly Johnson was a danger and a threat to the community, and that she should be released prior to her trial so that she could fight for her freedom while being around her family, friends, and her son, those that love her or whatever, right? And not somewhere that she does not belong. Holly does not belong in prison. Just like I think Carmelo Anthony doesn't belong in prison. But to be honest with you, I feel better about this case than I did about the Carmelo Anthony. It is a much different case, right? And we're going to go down some of the differences in this case, and then we're going to get into what the appellate court said and how the Supreme Court agreed with the appellate court. Let's do some comparisons right quick. Now, of course, we know there's different states. Carmelo Anthony was in the state of Texas, where Quadajah Holly Johnson is in the state of Illinois. Now, the alleged act, both of them was accused of first-degree murder. Carmelo alleged act was stabbing Austin Metcalf once in the chest at a school track meet, whereas Holly, her alleged act, she shot Romika Blackman several times during a street confrontation. The defense theory, Carmelo's defense was self-defense. He feared during physical confrontation. Holly, self-defense, long-term threat history, protective order, baby in a car, okay? So there's a whole lot more defense theories, okay? Not just self-defense. It's self-defense, long-term threat history, protective order, and her baby was in the car, right? Now, the weapon of choice for Carmelo was a knife, and they said he already pulled from the backpack, which, I believe they lied. But the Holly Johnson firearm, she reportedly had a FOID plus concealed carry license. Prior relationship with the deceased, Carmelo Anthony had no clear prior personal relationship with Austin. However, Holly had an ongoing personal conflict involving the same man being the father of their children. Prior threats / protective order, Carmelo Anthony had no protective order against Austin. They had no prior threats. They had no prior history between the two. For Holly Johnson, the defense says that Holly had sought out and obtained a protective order, a no-contact order, after threats were made by Romika Blackman. Key witness issue in the Carmelo case, Hunter Metcalf was on the witness list but did not testify, according to CBS updates. However, there were 21 witnesses that basically said that Carmelo Anthony was the one that provoked the incident and took it further, right? On Holly's case, the defense says she has surveillance, 911 call, and a witness positioning themselves that undermines the state's version. Now, the state do have 4 witnesses where all 4 of them are contradictory of each other in some type of capacity, and neither one of them was there from the beginning to the end. And one of the witnesses' testimony is very questionable, because she, per the defense attorney, says that she was not anywhere to where she could see what she say she saw or hear what she say she heard. Now, the outcome right now, Carmelo Anthony was convicted and sentenced. He was convicted of murder and sentenced to 35 years, whereas Holly, pretrial detention was reversed by a higher court, okay? Remanded for release conditions. Case is still pending, and they don't have no guilty or no guilty, not guilty yet, okay? Still pending. But the pretrial detention was reversed by a higher court, okay? It was reversed by the appellate, and then the state was upset because they didn't like that loss, so they wanted it to go up to the Supreme Court, trying to make it seem like this is a statewide problem for people who are charged with first-degree murder. And the appellate court said, nah, you tried it. This ain't got nothing to do with being no statewide issue. You just want this young lady to stay in jail because you trying to appease the family and you want to win them under your belt after the appellate court called your ass out. But we ain't getting involved, so let that girl go. Okay, that's basically what the Supreme Court had to say, right? Now, the main legal issue in Camelo's case was, did Camelo reasonably need deadly force after being confronted, shoved, and grabbed, right? Whereas in Quadajah Holly, the main legal question is, did Holly reasonably need deadly force after alleged threats to unalive her son, attack her on site, and being boxed in after Romika made a U-turn in the early mornings of September the 8th, okay? Those are the main issues. Now, the biggest difference between Carmelo Anthony and Holly Johnson is the prior threats. Now, we have heard plenty of times that all those threats didn't mean nothing. They're not going to mean anything, and that's not going to get her off. I'm telling you, the prior threats is big. Now, some people even came out here and said she went and got a restraining order because she knew she wanted to K.I. Romika all alone, and she was just trying to CYA, cover her ass, right? Nevertheless, I don't know where these type of people come from, but most people go to the court and they get these protection orders because they want to avoid harm, avoid danger. They're just saying, Your Honor, please keep this lady away from me because I want to keep my freedom and I want her to keep her life. So please keep this lady away from me. And that is what the courts did. However, she violated, even though she didn't get served, she knew about it. She didn't get served the final, but she definitely knew about it. So she violated and pulled up because, you know, she Romika. She Mika Meeks, right? Nevertheless, so Holly case, the defense has a much stronger pre-incident fear foundation. Why? Well, because the appellate court says that Johnson's attorney, which is Ari Williams, shout out to Ari Williams, argued that Holly sought a stalking no contact order because Romika had allegedly threatened her and threatened her family members on more than one occasions, right? And allegedly said that she was going to KI her. The court also noted that Holly had gone through the legal system before this incident ever occurred. And furthermore, the appellate court noted that Romika is the one that initiated this entire confrontation, not Holly. Holly did not sought out Romika. Romika sought out Holly. All right, she's the one that pulled up on Holly. And I'm so glad that they have that on video, that Romika is the one that busted the U-turn and pulled up and boxed him in. Now, the paperwork says boxed in. However you want to take it. I take boxed in as blocked. Whether the state want to say she was blocked or not blocked, the appellate court papers say boxed in. You do the math. Nevertheless, now I said, what is the edge up, the legal edge up that Holly has right now? All right. Now, even though she does have an edge up in this case because she did seek out a restraining order, and the appellate court did basically tell the circuit court, the state, that they had it wrong in thinking that she was a danger. Not even thinking that she was a danger. They just was not able to prove that she was a danger to the community. I think the Holly case is a little bit more solid, being that there was a protective order in place. She had already sought out to the court and said, please keep this lady away from me. She has already been threatening my life. She's threatening my grandmother's life. She's threatening my son's life. Please keep this lady away from me because I don't want to have to utilize my Second Amendment right to protect myself. Please keep her away. And how I know Holly was serious about this is because she asked for ex parte and was denied an ex parte. Most people, when they are denied an ex parte, they get discouraged and then they just give up. Holly didn't give up. Holly went back to court at least 3 or 4 additional times to ensure that she got this order. She went back multiple times. Just because Romika didn't show up do not mean that Holly slept on this. She did not sleep on this. She continued to seek justice through the court, right? She even went as far as having the court put an ad in the paper. So she really went to great lengths to get this order in place because She did not want to have anything to do with Romika, and she wanted to make sure that she was protected. So I say that she went to great length to keep Romika away from her, right? But Romika was adamant about seeing her, to the point where it was said by witness number 1, which is Carlos, that when she got out the vehicle, she said, I told y'all I was going to catch y'all, or something to that fact, right? I told y'all I was going to find y'all together, or I was going to catch y'all. So that was Romika's way of saying, I told y'all I was going to stand on business, and now I'm here right now to stand on business, okay? So let's talk about this edge up. Now, her edge is that the higher courts have already said the trial court was wrong to keep her detained based on the records that they had. So the state thought that they had a solid case, right? Because they had similar witnesses spewing the same things, even though their statements are inconsistent when you break them down, right? However, the state thought, I'm gonna put a first-degree murder charge on her, hoping that she cracks or maybe even asks for a plea deal or something like that, and she did neither one, right? So, however, they thought the proffer was mainly statements from witnesses, and it was mainly witness number 3. The state used that to secure a pretrial detention for Holly. That's why she wasn't released. And 2 judges basically agreed with the state and says, no, she is a danger and she needs to be locked up. And that's why I give a shout out to Ari, because if Ari was one of those sorry ass attorneys that was not really concerned about her client, she would have just sat there, but she did not. She kept filing motions and I like the way, even after the last one, the last denial, she said, I'm taking it up to the appellate court. Now, mind you, let's go back a little further. The first judge that denied Quadajah Johnson pretrial release, he said, now this is something that I heard, that he said, no matter how many times you put in a motion and try to get her out, I'm still going to deny it. Now that's what I heard. However, they changed judges, and the next judge denied her as well. So Ari took it upon herself and said, all right, I see how y'all playing state. We going up higher to the appellate court. Then when the appellate court came down and said, yeah, you didn't prove your case, state. No, that's not proving your case. I don't care about the circuit judge agreeing with you. You did not prove, but with clear and I think it's convincing evidence that she is a danger and there is no restrictions that can mitigate this danger, right? The court said you didn't prove anything. So the state got upset and was like, well, wait a minute. Only 2 of y'all disagreed with me, but 1 of y'all agreed with me. So we're going to take it up to the Supreme Court and see what they're going to say. And the Supreme Court said, nah, based on what you wrote and based on what Ari wrote, I'm going to go with the appellate court. This does not belong up here. And let me tell you why I feel that the Supreme Court didn't touch it. 1, because they were creating 2 entirely different stories. The state painted Quadajah Johnson as this monster, this cold-blooded killer. It was daylight. It was across the street from a school. It was kids there. She had a disregard for life. She was jealous and she wanted that man. And her poor baby mama, even though she busted a U-turn and pulled up on her, she was backing away. She was retreating. And this monster just moved forward and just shot her cold-blooded. And Ari like, hold on. You forgot to tell him that my client sought a protective order against your client because your client has threatened her life more than once. My client had her 6-month-old baby there, right? My client have received death threats from her. My client family has received death threats from her. My client had a concealed carry license. My client has a straight and narrow criminal background. Your client was the aggressor. My client was minding her damn business, right? Your client is the one that pulled up on my client. So because they were painting a totally different story, the Supreme Court said, this ain't got nothing to do with us. And this ain't got nothing to do with the state of Illinois. They figured out that the state, the prosecutor, was trying to use this, this is a statewide issue. They tried to play in the Supreme Court's face, right? Trying to say, well, if you let her out, then we have to restructure how we look at everybody that's being charged with first-degree murder. They're like, no. See, you lost at the appellate court and you want us to overrule the appellate court decision. And the state even asked for Holly to sit there until the Supreme Court made their decision. Okay? I know that's a hard thing to do when it comes to Holly having to sit there, and Ari even having to tell her client, you gotta sit, you gotta wait. Okay? But the Supreme Court came back only 2 days after Ari submitted her answer, right? Submitted her answer to the Supreme Court, right? Regarding the state's appeal. And the Supreme Court basically says, your appeal is denied, state. We're not getting involved. Whatever the appellate court said, that's what we're gonna go with. This is not a Supreme Court issue. You're mad because you lost at the appellate level. We're going to take it back down to the appellate level, and we're going to do whatever the appellate court said. The appellate court said they're going to send it back down to the circuit level, and they want the circuit judge to come up with a restriction to release this young lady because the state failed to prove that she is a danger to society, to the community, okay? Nevertheless. And the reason why they failed to prove it, because when you put everything together, she did not seek out Romika. This would not have even been a situation had not Romika bust that U-turn and pulled up on her. This was a one-on-one incident. Holly did not wake up on September the 8th and said, I feel like shooting at somebody today. No, she would not have had to pull out her weapon and fire her weapon had not her already documented stalker pulled up on her, right? So let's continue. Now, the state was arguing about the appellate court was already looking at a defense for Holly. They said that in their answer, that the appellate court is already looking at self-defense and we're not there yet because this is pre-trial. They did do that, but they did it based on, this is just not a random case. This is a self-defense case. Had not this took place first, then this would not have taken place. So there are several things, and let's look at it. The appellate court said Holly did not seek out the confrontation. The victim confronted her. Now, this is in the write-up from the appellate court's paperwork. Again, Holly did not seek out the confrontation. The victim confronted her. Number 2, Holly had sought and obtained a protective no-contact order before the shooting. To be exact, she went for the order December 2024, but she was not granted the order until July 2025. And when did Romika pull up on her? In September. So July, August, September, in less than 2 months after the court gave her the order, did she get pulled up on? Less than 2 months, you guys. So again, Holly did not seek out the confrontation. Romika did. Romika confronted her. Holly sought out and obtained a protective no-contact order before the shooting. Holly stayed at the scene and cooperated with the police. She did not flee. Holly had a FOID card and a concealed carry license at least 5 or 6 years prior to this incident. And the court viewed the case as a very personal and specific controversy, not a random public safety threat, okay? So the reason why this matters is because the appellate court basically said, this is serious, but the state has not shown that she is such an ongoing danger that she must sit in jail until trial. Meaning the state failed. The state failed to identify her as this dangerous monster that they wanted to paint the picture of. They failed to meet that burden. That's on them. That's not on Ari. That's not on Holly. That's on the state. They failed to prove that she was such a danger. You can say it all day long. Oh, she is dangerous. She is a danger. She is a danger. Well, the state didn't prove it. The state didn't prove it. So now the edge Holly has now. Her first edge is relief leverage. Her attorney can walk into the trial court and say, The appellate court already ruled detention was improper, meaning that she was never supposed to be locked up in the first place. She should have been released when the state failed on December the 4th to prove that she was a danger to the community. She should have been released then, but Ari can go in there and say, set the conditions and release my client. Now, the trial judge still gets to decide what conditions, and we already know they may try to throw the book at her. We know it's coming because they mad. They lost not once, but twice. They lost against the appellate. They lost against the Supreme. They mad. I would be too, okay? The second edge is the narrative validation. The defense story is no longer just what Holly's lawyer is saying. It has been recognized by the appellate court as important enough to reverse the detention. That is powerful for public perceptions and for future motions, all right? So the appellate weighing in saying the state failed to prove that she was a danger already. The appellate court said the state has failed, which means now the rest of the state's argument will be scrutinized. It will be looked at very carefully. They already done failed at all that other shit that they put a whole lot of sugar on, right? Now, their remaining arguments will be scrutinized, all right? Now, the third edge up is the state already lost one major fight. That doesn't mean the state murder case is weak overall, but it does show the state struggled to prove that Holly is an ongoing danger under the pre-trial standards, okay? Now, the fourth edge up is the protective order history is now front and center. The appellate court specifically mentioned that she sought and obtained a protective order as legal and appropriate way to avoid the violence between her and Romika. So that gives Ari a strong argument later that the jury should hear about her fear, her prior attempts to use the court system, and why she believed Romika was a threat. So the fact that the appellate court doubled down and mentioned in their reports that Holly Johnson sought out and obtained a protection order as a legal and appropriate way to avoid violence. The appellate court wrote that, y'all. Basically, they saying, listen, this person that's being charged with first-degree murder, she took it upon herself to obtain a protective order. She did this to avoid violence, not create violence. Ari can absolutely use that in her argument now. She tried to avoid it. She didn't just say it. The appellate court said it too, okay? So, again, that's why one of the reasons why the state was mad, because the state was saying, you are already trying to create this as a defense case. This is not a defense case. This is cold-blooded murder. That is what the state of Illinois prosecutor wants people to believe, that this is not a self-defense case. This is a cold, calculated murder, right? Where the appellate court said, you can't say that. Because she went as far as going the legal route, trying to protect herself, trying to protect Romika as well. She did not want violence. She wanted to get away from it. She wanted to avoid violence, okay? However, let's continue. Now, let's go down to the 10 reasons that the appellate court used to reverse this detention stay, okay? Let's start from the top to the bottom. Number 1, Illinois law presumes pretrial release even in murder cases. So the appellate court said that the state had to prove by clear and convincing evidence that Holly was a real and present threat, and no release conditions could control that threat. The court said the state did not meet that burden. So the appellate court right off the bat said murder alone, or being charged with murder alone, does not prove that you are a threat to the community, all right? That's number 1. The appellate court is saying this. Number 2, the confrontation was personal and specific, not random community violence. The appellate court said this case grew out of a specific conflict between Holly and Romika alone. It was not gang activity. It was not a random violence or a broad danger to the public. This was between Holly and Romika. Number 3, the appellate court said Holly did not seek out this confrontation. The appellate court said that it was undisputed, meaning that, listen, you know this, I know this, and everybody know this. This is undisputed that Romika is the one that confronted Holly, rather than Holly hunting Romika down. Now, I think that should be number 1, but it's number 3. Nevertheless, I think that is a strong one, and I'm so glad that the appellate court put this in their write-up. The appellate court, let me read it again, you guys. The appellate court said Holly did not seek out this confrontation. The appellate court said that it is undisputed that Romika Blackman is the one that confronted Holly, rather than Holly hunting down Romika Blackman. Okay? Number 4. Appellate court said that Holly had already sought legal protection. The court emphasized, doubled down, tripled down that Holly sought and obtained a protective no-contact stalking order before the shooting, which the appellate court called a legal and appropriate way to avoid violence. She didn't want no violence. She wanted to be left the fuck alone. What part of leave me alone did Romika not understand? Okay, number 5. The appellate court said she stayed at the scene and cooperated with the popo. The appellate court found that to be very important because it suggests that she is not trying to run, she is not trying to flee, she is not trying to hide, and she's not trying to threaten no witnesses. She stayed right there and she cooperated with the police. Number 6. The appellate court says she was out for almost 3 months before being arrested and did not create new problems. The shooting happened September the 8th of 2025. She was not arrested until December the 3rd of 2025. 87 days free. The appellate court said that time period alone showed that she had not posed an ongoing threat while she was out of custody for 87 days. She ain't hurt a flea. She ain't hurt a flea. Number 7. She had little criminal history and no violent background shown. The opinion of the appellate noted that her only criminal history was nonviolent, and the state did not present any evidence showing that Holly Johnson was violent, abusive, or had any type of assaultive history. She kept her hands to herself. The appellate court said, state, you want to say she's so violent, where is your proof? Where is your evidence? There is none. Number 8. She had a FOID card and a concealed license. The appellate court said this matters a lot because it suggests that she followed the firearm laws before this incident. So a court order banning her from having a firearm could realistically work as one of the release conditions. Just say she can't use a damn weapon. If she followed the conceal and carry rules before this incident, then what make you think that she won't follow it afterwards? Okay? Number 9. The court believed release conditions could reduce any risk. The appellate court specifically said conditions like no firearm could address the safety concern here instead of keeping her locked up and detained until she goes to trial. Just take her weapon away. That could alleviate one of the safety concerns, right? No firearms. That's what the appellate court said. Number 10. Now, this is the one that people are running with, right? All the 9, no one wants to mention that. But number 10, it says she was pregnant, and Illinois law disfavor forcing pretrial detainees to give birth in custody unless necessary. So the appellate court says that she should be released sooner rather than later to prepare for childbirth in her trial. Now, of the 10 things that I just gave you that the appellate court used to reverse the order, some people only want to focus on number 10, and that is that she was pregnant. And the appellate court thinks that she should be released sooner than later. They don't want to focus on the fact that the appellate court said that she had already sought out a legal protection. She was not the aggressor in this confrontation, okay? That this confrontation was not random, right? This wasn't just no random thing. Oh, I wake up on September the 8th and say, oh, I want to shoot somebody. No, this was not about this. It was personal and specific. Romika ran up on her and she protected herself, all right? So now let me just say this. The appellate court did not say Holly Johnson is innocent. It said the state failed to prove that she is such an ongoing danger that she must sit in jail until her trial. The court focused on her protective order, Romika confronting her cooperation with the police, her lawful firearm status, her lack of a violent history, the fact that she had a 3-month delay prior to her arrest. She was free for 3 months, and the fact that the release conditions could control the risks, all right? So those are the things that the appellate court gave as reasons why they said the state failed to prove that she was a threat to the community and a danger to the community. Now, let's talk about reasonable doubt, shall we? Now, we know that the burden in a self-defense case is solely on who? It is solely on the state. The state has to prove that it was not self-defense as long as a self-defense is raised. And y'all, it has been raised, honey. It has been raised. Even the appellate court is taking that the self-defense has been raised. Half of Ari's job is already done, okay? Half of Ari's job is already done. Self-defense has to be raised, and it's already been raised, all right? So self-defense will be Quadajah Johnson defense. Now, it's up to the state of Illinois to prove beyond a reasonable doubt that it was not self-defense. But let's talk about the reasonable doubt that already is here. It already presents itself, right? So let's talk about why the defense has a reasonable doubt right now. The defense has several facts that can make a juror pause before convicting Holly Johnson of first-degree murder. Let's go down the list, shall we? First, Holly had prior documented fear. The appellate opinion says that she sought out and obtained a stalk and no contact order before the shooting. That helps with her argument. I wasn't making up the fear after the fact. I had already tried to use the court system, and the appellate court treated that as a significance in reversing her detention. So she already, listen, the judge said in July of 2025, I am going to grant this default order, basically, because she proved that she was in fear of her life. She was already in fear of great bodily harm that Romika would oppose upon her. It was already documented less than 2 months prior to the incident. How can you be scared in July? Or not scared, but fear. How can you be in fear in July and you ain't in fear in September? Baby, fear is fear, okay? So that's the first one. The second one, deceased came to her. She started the confrontation, not the other way around. So the appellate court said that Romika confronted Johnson. That matters because it lets the defense say Holly was not hunting her down or creating a confrontation. It was the other way around. Another reason why the defense has a reasonable doubt is that her baby was in the car, and that helped explain urgency and fear. If Ari can show that Romika rushed toward the car where the baby was, then that would be very powerful. A jury may understand why Holly believed that this is just not a fight between two women. It involved her child being nearby as well. Yeah, baby Carson. Thank you so very much, baby Carson. So baby Carson at the time was 6 months old, and you gotta remember, baby Carson was also under the restraining order. The restraining order says, stay the fuck away from me and stay the fuck away from my baby, okay? Now y'all know that Romika wasn't too fond of Holly being pregnant with Carlos's baby, right? So she was standing in front of her car where her baby was in the seat behind her. And where did Romika's body drop? Right by Holly's car, all right? So now that's third, the baby being in a car. is going to be a powerful thing. We may not have put a lot of emphasis on it now, but if Ari is on top of her job when it comes down to trial, she is going to amplify the fact that baby Carson was there. And so she was not only just protecting herself, she was also protecting her son. All right. Now, the next one is that Holly stayed and cooperated. Okay. So these is all reasons for reasonable doubt. It's already there, right? Holly stayed and cooperated. That does not prove self-defense, but it does help her look less likely like someone who knew she committed a murder, and more like someone who believed she had a reason to do what she did. She didn't try to flee. She did not try to flee. She stayed right there. Now, fifth reasonable doubt. She was apparently out for months before her arrest with no violence, and the appellate court saw that as important to the pretrial danger analysis. That helps push back against the idea that she is just a reckless danger to everyone. All right? Now, I gotta be fair. Let's talk about how the state can try and knock the reasonable doubt out the ballpark. All right? So the state can come back and say, yeah. I understand she had an order. I understand her baby was with her. I understand that she cooperated with the police. I understand that she was out for 87 days. And I understand that Romika ran up on her. I understand all of that, right? However, we are not trying the protective order right now. We are trying the shooting. This means they will even try to say, if Holly feared Romika before all of this, then was deadly force necessary in the exact moment she pulled the trigger? They're going to say, Romika was unarmed. She had nothing in her hand. What is it for you to fear? They're going to say, witness number 3 said that Romika was backing away when she broke away from the chokehold. If she's backing away, she was no longer a threat to you. Okay? They're going to say, why did it take 3 shots with 2 of them hitting her? It was excessive. They're going to say the children were there, but other people were there as well, and you did not bother by shooting into the air. They're going to say you could have gotten in your car and driven away. They're going to say prior fear alone does not give someone permission to pew someone. Okay? So the state's best lane is they have to convince the jury of this. They have to convince the jury. We understand why Holly was scared, but we do not believe that she had to shoot when she did at that very moment. Why did she choose to pull out her weapon? Oh, I forgot. The state is also going to say a witness said that she went back to her car to retrieve her weapon after making a verbal provocation that I'm going to shoot you, bitch, which only one witness have said that thus far, and y'all already know. Holly gonna break her down like an M16, and I can't wait. Nevertheless, let's talk about the make or break issue here. The biggest issue is going to be movement and timing. Was Romika moving away from Holly when the shots were fired, or was she moving toward Holly, where the baby was? Now, I love this part. The reason being is because the evidence, baby. The evidence does not say that she was retreating. The evidence does not say she turned away, she slid away, or she backed away. We already know the trajectory of the bullet wound says front to back, which means that she was facing Holly when she was shot. But let's go a little further, baby, because the body of Romika dropped right in the front door area of Holly's car. So she was backing away from where? Holly's car? She was too fucking close in the first place, if you ask me. So, backing away, the bullet going from the front to the back does not prove that she was backing away, especially when you put all the other context to it. They said Holly was standing on the sidewalk when she made the first shot, and then she walked toward Romika when she shot again and again. Here's the thing though, how was that possible when she landed right by Holly's car? Because Holly says, and the defense says, Holly was standing right by her car. standing right by her car when Romika ran up on her, swung on her, grabbed her hair. And while they was in a tussle, Holly shot. But furthermore, y'all, now listen to this. The DNA results are in. I don't have them. I do not have them. But what I do know is there is a photo that's floated around where Holly Johnson was drenched in blood. She had blood on her front top area of her jacket. And then she had blood on her pants below her knees. She had blood on her socks. And she had blood on her shoes. Well, guess who fucking blood it was? Damn sure wasn't hers. And it damn sure wasn't Carlos. She had Romika's blood on her. Okay? Now, the state is going to try to argue that the blood got on her because it was a close range shot. How you gonna say it's a close range shot? If you just said that Romika was backing up and that Holly shot from the sidewalk. Make it make sense. You gotta be able to put all that shit together and make it make sense. How did she shoot from the sidewalk and then came off the sidewalk walking toward Romika, but all of a sudden she got blood on the front jacket, and it's smeared blood, not just sprinkled blood. It wasn't just droplets. It was smeared blood on the front of her pants, on her socks, and on her shoes. Now, I don't have the DNA report. I can't wait till I get a hold to it because I can almost rest assured that her DNA was on other parts of Holly's body. So we just gotta wait until that come back. It has come back, but it has not been released as of yet. But baby, once it's released, I will be reading that as well. All right. So is there reasonable doubt? It absolutely the fuck is reasonable doubt right now already. And it's going to be an uphill battle for the state to get rid of the reasonable doubt. They would have to convince the jury that even though Romika made death threats to her, to her family members, even to her newborn baby, okay, that Holly was not afraid of her, that Holly was not scared, that Holly could have fled. Although in the state of Chicago, she has no duty to retreat if she cannot reasonably get away, and she couldn't because her baby was in the backseat of the car without causing harm or danger, right? Or if she feels that her life was in danger, right? So now, let's talk about the DNA on Holly's body. Romika's blood being on Holly's clothing, her socks, and her shoes. How does this help the defense? Well, one, it proves that they were very close to each other when this situation happens. So it supports a confrontation being physical and not just verbal. It supports chaos and immediacy. The blood transfer like that can make the scene look less like a calm, calculated shooting and more like a violent encounter. It supports Holly's fear. If Romika was close enough for blood to get onto Holly on her clothing and her socks, then the jury may better understand. She's saying she felt fear and danger. And it also may support the baby car argument. If the defense says Romika was rushing toward Holly or even Holly's car, the blood pattern could help show the distance between them was very, very close. All right. Now, the state can try to use it, and the state may argue the blood spatter is expected when someone shoots at a close range. They said she shot once on the sidewalk, came off the sidewalk, and shot 2 more times with another bullet hitting her, right? The state may argue that the close shot range mean that Holly intentionally fired while Blackman was near and vulnerable, right? The state said there was no physical violence between the two ladies, that they did not touch each other at all, which means Romika blood should not be transferred on Holly in a smearing way. It should only be driplets, like splash, 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 but not smearing. If the DNA comes back and say that there was blood smears on Holly in any type of capacity, then that's going to knock down the state narrative that there was no physical contact. And it's going to prove the defense narrative that, oh yeah, yes it was. There was physical contact. There was a struggle. There was grabbing, and there was transfer of DNA from Romika onto Holly. All right. So that's going to help Holly a whole lot more than it helps Ramika if it comes back that she has smeared blood on her, okay? Let's go into the backing away one more time. So the state wants the jurors to believe that Ramika was backing away, that she was giving up, she was retreating, okay? But the trajectory of the bullet helps Holly more than it helps the state, because a backing away argument, it depends on how the bodies were positioned. So if Ari hires a forensic experts that come in and say it is impossible to be backing away and have the bullet go front to back, that means that you are facing your shooter. You are that close up on your shooter. And the fact that one landed in the face and one landed in the thigh, meaning that there was movement forward, not backwards. There was forward movement, not backwards movement, all right? Now, she's gonna need a forensic expert to come in and talk about the front to back trajectory of the bullet, but also the blood being on her front jacket, her pants, her socks, and her shoes, okay? Because they're gonna have to explain how the hell did the blood get there. Now, I may not know, you guys may not know, the state prosecutor may not know, and the defense attorney, Ari, may not know. But these forensic experts, they can come in and they can break it all the way down, and they can say whether or not it's consistent with a close contact struggle, whether or not it's consistent with transfer from physical touch, whether or not it's consistent with gunshot splatter. And they can also say, does it support Holly's version that Ramika was close, rushing, or physically engaged? This is huge because the state says no struggle, no touching was involved. However, if forensic science suggests close physical contact, that will kill the state version, flat out kill it, all right? Now, they will also need a shooting reconstruction expert. If the defense hire someone to explain the bullet trajectory, the body positioning, the distance, and the final body location, if both shots was front to back and Ramika dropped near Holly's driver's door, the defense want an expert to come in and say, this is consistent with Ramika facing Holly near her car, not with someone safely backing away from the danger. Now, the state can say that she was facing Holly, still facing Holly while stepping away, but the defense can use reconstruction expert to argue that state's version does not fit with physical evidence, baby. It just don't fit. And if it don't fit, what? You must acquit, all right? Now, there is no surveillance video that shows frame by frame, and that is actually more in the defense favor, right? Because the state can come and say anything they want. This happened, that happened, that happened. But guess what? They gotta prove that shit. They have to prove everything that they say happened. Oh, she stepped off the sidewalk and she rushed toward Ramika with a gun in her hand and she fired multiple times. Prove that. Prove that she was on the sidewalk. Oh, well, witness 3 says she was. Well, Ari has already, and I like the fact that Ari put this in her argument to the appellate court. Ari already told the appellate court that witness 3 could not possibly see what she say she saw or heard what she say she heard, okay? Let me read it directly, right? It says, in the appellate opinion, it said the defense argued that the video footage showed the state witness number 3 could not have seen nor heard as much as they claimed. The appellate court says the opinion specifically says defense counsel argued that witness number 3 claimed Holly and Carlos did a fist bump after the shooting, but was not in a position to have even seen Holly after the shooting, and also did not report the alleged fist bump to the police at first, okay? Now, that's a big credibility issue. They have witness number 3 on camera ducking behind a building, and they also have witness number 3. They even have her when she crossed from the yogurt store across the street going toward the incident. They have her on camera when she first made it there. So she was not able to see what she say she saw or hear what she say she heard. Now, Ari put that in the motion up to the appellate court. And I like that she did that because that's already there. That's already there. Okay. So the opinion also says that defense counsel Ari brought up video evidence showing that Holly had disheveled hair when the police arrived. When the defense argued, made it look like she had been attacked, right? The defense also pointed to a 911 call where an anonymous caller said that two women were fighting and that Romika was the aggressor. So yes, the defense absolutely is saying these witnesses could not see everything they claim they saw, and the physical evidence and the video evidence does not match the state's version, all right? Now, that matters because if the state is leaning on witnesses to say that there was no struggle, that there was no touching, or that Romika was actually backing away, the defense can attack that by saying the witness was not even close enough to see that shit. So how the hell can you depend on this witness when they weren't even close enough? They don't know. They ain't got ESPN or ESPNT or whatever, how, that little whatever you have when you can see through walls in the future and stuff, right? So nevertheless, the Ari right now has reasonable doubt. It's going to be an uphill battle for the state to knock down that reasonable doubt. So right now, everything is in favor of the defense thus far. It is. It just is. It is. Okay? Now, let's name the things that the defense needs in order to make the case strong. And we're going to end here. All right? We're going to end on the things that Holly Johnson's attorney need to make this case a solid, sealed, and delivered case. One, I said a forensic expert to explain how did Romika's blood get on Holly, right? Number two, a shooting reconstruction expert, okay? And that shows the bullet trajectory from the front to the back. Is this of someone that's backing away, or is it consistent of someone moving forward, all right? Number three, they need proof that the baby was in the car and Romika was moving toward the car, okay? So if they could prove that baby Carson was in the car and Romika was moving toward the car, that's going to be good for them as well. And the reason being is because, one, her body landed right by the car, so that's proof right there. Number four, proof of prior threats and a no contact order was in place, okay? The defense should make the protective order history clean and simple for the jury to read. Not just, oh, they have drama. No. They need to break it down that Holly was afraid of Romika before this day. She went to court because of it. She sought legal protection because of it. She did not just invent the fear after the shooting. She feared this young girl, and that's why she went and got the protective order in place. The next one, they're going to need that 911 call that says that, it says 911 call, police reports, or any messages, anything showing that Romika had threatened Holly before, followed her before, harassed her before, or violated boundaries before. Violated boundaries makes Holly fear more reasonable. So any threats, I'm gonna get you on site. I'm gonna get you when I see you. I'm gonna do this to you. I'm gonna do that. They need all of that. They need all of the messages, text messages, voicemails, social media threats, police reports, prior 911 calls, protective order paperwork, witnesses who heard the threats. All of that. They're gonna need all of that, right? And that can show Holly's fear was not imaginary. It was real, all right? The next one, proof that Holly did not chase or seek out Romika. That's easy. Hell, the appellate court already said that, right? The defense needs to keep repeating, Holly did not go looking for Romika. Romika came to her. Holly did not approach Romika. Romika approached her. Holly did not seek out this confrontation. Romika sought the confrontation out with her, okay? That matters because the jury often look at who started this shit, who approached who, and who had the chance to avoid it, right? Some people don't think that that's big, that Romika bust a U-turn and pulled up on Holly. But I've said from day, I ain't gonna say from day one, because I was a little confused on day one. I didn't know all about it. But week one, I said it from week one of me covering this case. I said it from week one. Romika started this shit. Romika approached her. A lot of people didn't think that that was important. It don't matter. She went there to see her baby daddy. She just wanted to see her baby daddy. That's all. She just wanted to see her baby daddy. Fuck out of here. She was there to start some shit with Holly, period. She bust a U-turn and pulled up on them, period. She was not supposed to be there, okay? The next one, they need evidence that Holly car was boxed in. Now, I used the words that was used in the appellate's order, right? The appellate order reiterated that Holly car was boxed in. Now, I didn't say blocked in, I said boxed in. Boxed in was the words that they used in the appellate's motion, okay? Now, this could be one of the most important parts, because if Holly car was blocked by Romika car and Carlos car, then the defense can argue she could not safely drive away. And that is something that the state keeps arguing. She could have left. She could have left. She could have drove away. In the appellate court's argument, in the appellate court's motion or response, they agreed that her car was boxed in. It was boxed in. It was the fuck boxed in. However you want to say box, block, box, it rhymed to me, okay? It rhymes to me. Block, box, it was boxed in. She could not get out, okay? Now, and she couldn't get out safely. Now, she could have been some Rambo and ran through other cars or whatever. Why put yourself in danger, right, with your baby in a car just because you got a maniac that ran up on you and they want to get their little one-on-one or they one-to-the-one or whatever the hell she said, all right? So that helps defeat the state argument that she could have left. How's she gonna leave? She ain't Batman. The car didn't have no damn wings. Now, another thing that could help Holly's case is the defense attorney, Ari, humanizing Holly without overdoing it. So the defense attorney can say things like, Holly stayed at the scene. Holly cooperated with the police. Holly had no violent background. Holly legally carried her weapon. Holly was pregnant at the time of all of these threats that came through. Holly baby was present on the damn scene. And Holly previously used the court system instead of violence. That paints her as someone who was scared and cornered, not someone who went looking to KI another person. Now, another thing that could actually help bring this home for Holly is if the defense attorney prepare her carefully if she testifies. If Holly chooses to testify, she has to be very careful. She doesn't have to, because it's up to the state to prove that it wasn't self-defense. However, her testimony could help a lot because self-defense is about what she believed in that moment. It's not about what the jury thinks. It's not about what Ari thinks. It's not even about what the state thinks. And it's damn sure ain't about what Romika supporters think. It's about what she believed in that moment. But it can also hurt her if the state cross-examine her hard and makes her look angry, jealous, inconsistent, or reckless. So if she testifies, her message needs to stay simple. I was scared. I believe she was coming toward me and my baby. I believe she came to do what she consistently threatened me that she would do. I did not think I could safely leave. I fired because I believed we were in immediate danger. Now, let me just tell you my honest take. Holly is a very mild-mannered, calm, non-aggressive woman. I believe her testimony will ring bells. I do not believe that the state can trap her to get angry or anything like that. I think that if she come on a panel, I don't know if she will or not, but I'm just saying, if she did testify, if I was her, I would. If she did testify, I believe that she would knock it out the ballpark because she is a soft-spoken, very calm. She's not a Romika. She's quite the opposite. She's absolutely not a Romika. I believe that she will be able to relay her message in a calm, non-confrontational tone and just tell the truth. I was scared. I believe she was coming toward me and my baby. I did not think I could safely get away. I fired because I believe we were in immediate danger. I do believe that everything, like I said before, is in favor of the defense right now. There is a uphill battle for the state to be able to prove that she was not in fear of her life. She had her baby there and everything. Like, what the fuck? If someone pulls up on you acting like they Rambo after threatening you, after you have tried to block them, then they hit you up on Instagram, they calling your friends on Valentine's Day, accusing your friend of being the father of their... It's so much, y'all. It's so many things that Holly can use to show that Ramika was off her rockers. She was obsessed with that girl. She was obsessed with harassing that girl. She didn't just harass her, she harassed her family. She harassed her friends, okay? So there's so much right now that the state would have to, knock down. And how you gonna knock that down when it's already done went up to the appellate court? If the appellate court recognized a lot of these things as the reason why she is not a danger to the community, then this is a good sign for Holly Johnson, all right? So with that being said, we all know that a pretrial release does not mean Holly is going to be free when it comes to the trial. It still has to play itself out, but I still stand firm and believe that Holly will beat this case. I would like to give a big, huge shout out to Ari, because Ari is not sleeping on this case. Ari is all gas on this case. Ari is all the way in. She is determined to fight this case to her best ability, and I love that. Now, a lot of people, when they're told no, they give up because they feel discouraged, and they say, forget it, we'll just wait, we'll play their little game. But Ari did not do that. Ari was told no 2 times by a circuit judge, either 2 or 3, that her client could not be released. She took it to the appellate. The appellate said they agree that the state did not prove their burden. They had no burden of proof. Then the state fired back and said, we're going above your head and we're going to the Supreme. When the appellate court came back and said, okay, we agree with you, state, take it to the Supreme, right? That looked like another loss for Ari. And Ari said, we're not taking this loss. We're going to fight the Supreme Court. And when I found out that this was Ari Williams' first time having to go up to the Supreme Court with any case that she has ever covered, I said kudos to Ari. Because Ari could have said, no, I'm not ready for the Supreme yet. I've never done this before. I don't want to do this because it may give me a bad reputation if I lose. She didn't do that. She said, oh, you want to go to the Supreme? Then let's go to the Supreme. And she did exactly that. She went up to the Supreme right with the state. Now, in my opinion, I believe the state thought that she was going to sleep on that and not respond to the Supreme, but she didn't. She fought the state all the way up to the Supreme Court and she won. I don't care what anybody think about Ari. She scored a big one, okay? Now, this does not mean the case is solved. This does not mean the case is over, but to not give Ari her kudos for securing a win from the Supreme Court. And a lot of people may say, oh, the Supreme Court didn't look at it. Hell, that's exactly what she told them to do, not look at it. If you read Ari's response to the Supreme Court, she asked them, after telling them everything that she told them, she said, my request is for you to not accept this case. They did not accept the case. Now, some people will go around and say they didn't even read it, but come on. Do you really think the Supreme Court didn't read it? How would they know to reject it if they didn't read it? Stop believing the BS, you guys. Please stop believing the BS. They read it. They read the state's. Then they waited for her response and they read hers. 2 days later, 2 days after she submitted her answer to the state and asking the Supreme Court to not accept the state's case, they rejected the state's case. Ari won a big one. She's dotting all of her I's and crossing her T's. She's not taking this case lightly at all. Kudos to Ari Williams.
Let's keep the conversation going down in the comments and make sure you like, share, and subscribe to my channel and Loud Talkers. Y'all make sure y'all keep it loud out there in these streets. Until next time, bye-bye.